You do the best you can with what you're given, and you try to get a little creative. Do the best you can for the case and the facts you're given. I had a client who was involved in a car accident, a serious accident with a truck. The client was very badly hurt. The facts of the case were just terrible. My client was driving in New York City, Manhattan. It was actually on 57th Street, and there was a large truck that crossed over the double yellow line and just hit my client head-on collision. Very bad accident, and my client suffered very bad injuries. He was a 23-year-old guy who was very badly hurt and, will not be able to work again. He wanted to be a police officer. He was well on his way to doing that, and that was cut short and put to an end. So the damages were very significant. Now, in that case, the truck only had $1 million in coverage, and I knew that my client's injuries warranted a recovery of greater than $1 million. What I wanted to do was I wanted to see if there was a way that I could try to recover more than that for this client. The insurance policy of the $1 million, I knew I'd be able to get that. The question was there something I could do, some way that I could find additional coverage or an additional way to collect for the client? Again, the defendant in this case was a corporation that owned that truck, and the corporation had no assets. There'd be nothing to recover from that corporation other than the insurance they had, which was the $1 million. So what I did was, when I deposed the defendant, rather than just asking questions about the accident and how it happened, because I knew about all that already, I knew it from my client, and I had a non-party witness who saw the accident, who I had spoken to, and who told me this was clear as day that the truck crossed over the double yellow lines. I didn't limit my questions to that. I also deposed the owner of the company, and I asked him questions about the nature of the relationship that his company had with the master distribution company that his company worked for. In other words, this was a beverage distribution company, and his company had a contract with a larger distributor in order to distribute these beverages. And what I was trying to do is I tried to show that the nature of the relationship between these two companies was so tight and so connected that it was not an independent contractor relationship as the company was trying to argue, but rather was almost like an employer-employee relationship. And that's significant, because if I can show that it's an employer-employee relationship, then the master distribution company is going to be responsible by law, by what we call respondeat superior, for the actions of the employees of that distribution company. And if that happens, if they're responsible by law, then I've just gained access to a tremendous amount of potential recovery, because they have a significant amount more of insurance than just the smaller under company. Actually, that case is still being litigated right now. I hope I can bring that to a successful conclusion. But the point there was I tried to get a little bit creative, think a little bit outside the box to get the client the recovery that he really is entitled to, because again, his injuries were very significant and I believe would otherwise be worth well in excess of just the $1 million policy that the underlying company had.